Hello and welcome to this episode of Parley, the Hindu's weekly podcast where we attempt to present contrarian views on news that has animated public discourse. I'm Kunal Shankar and I'm based in Chennai, India. On July 23rd, the International Court of Justice delivered a landmark advisory opinion on climate change. The ICJ, which is sometimes referred to as the UN Court, has reaffirmed a range of international laws which affirm states' binding obligations to prevent environmental harm and uphold human rights. These laws range from the UN Charter, the climate treaties such as the UNFCCC, the Kyoto Protocol, Paris Agreement, and the United Nations the unique clause, United Nations Convention on Laws of the Seas, Ozone Layer and Biodiversity Conventions, even customary international law. Crucially, it has also upheld the common but differentiated responsibilities that is crucial for developing countries. The court's ruling has been praised for empowering climate litigation and codifying justice for vulnerable nations, while critics argue it overreaches legal precedent and risks politicizing the judiciary. Proponents see it as a long overdue moral and legal reckoning, while skeptics caution against legalistic pathways slowing innovation led transitions. The ruling indeed raises critical questions about enforcement, equity, and the balance between legal mandates and market based solutions. Now, to discuss these critical questions, I'm joined by Ted Nordhaus, who is an American environmental thinker and co founder of the California based Breakthrough Institute. He advocates for what he calls eco modernism, promoting technological solutions like nuclear energy and decoupling economic growth from environmental harm. His work challenges conventional environmentalism, emphasizing innovation over regulation. He co authored a seminal book in 2010 with Michael Schellenberger called The Death of Environmentalism. He joins us from Berkeley in California. Our other guest today is Anand Grover, a senior lawyer and human rights advocate known for his pioneering work in matters related to human rights and the health rights and the HIV/AIDS law in India, a former UN Special Rapporteur on the right to health. He has co founded the Lawyers Collective, a pro bono legal aid service, and has also argued key constitutional cases on access to medicine, LGBT rights, and on matters related to environmental and public health. He joins us from New Delhi. Thank you both. Thank you, Ted, and thank you, Anand, for making time today.
Thank you.
Thanks for having me.
Thank you. So, Ted, maybe if I can begin with you, if you could tell us, give us, prior to understanding its legal implications on nations, what are your initial thoughts on the ICJ ruling?
Well, I think that there are a set of problems here. I think if you kind of take this ruling to say international law could in the future result in sort of international obligations, criminal proceedings, what have you, against nations who are responsible for emissions in response to climate impacts caused by those emissions. In a purely sort of theoretical sense could be true, but for sort of any of that to actually materialize, first of all, you have to have, real impacts that are predominantly driven not by climate variability, but by climate change. You have to be able to not only sort of detect trends in various underlying physical phenomena in terms of climate and weather. You have to be able to attribute those trends to climate change. And the reality is right now with, somewhere between a degree and a degree and a half of warming globally, there's actually not that many climatological phenomena where you have sort of a very strong anthropogenic climate change signal. That doesn't mean that the planet has not warmed. It has. We can measure that. But when you get to, climate change is not causing droughts or heat waves or cyclones or other phenomena that would not have happened in the absence of climate change. It is in the most kind of clear cases very modestly amplifying things that would have happened anyway. And then you have to go and look at what the consequences are for people who end up in harm's way and the degree to which that modest intensification of a climate hazard versus the other phenomena that we know actually sort of affect or are actually much more determinative of the degree to which there are human or economic costs have occurred. So, uh, what, how many people are in harm's way? We have huge populations that are migrating towards climate hazards now, not away from them, into flood zones and coastal areas because that's where economic opportunity is. So all of these things sort of make any actual adjudication of these questions extremely difficult to do, and I'm very skeptical that this will ever result in, particularly compelling or actionable findings or international legal action.
Thank you so much for that, Ted. Anand, if I can have you respond to that and your initial thoughts on the ruling.
Well, I generally tend to agree with that, but let me just amplify this point. First of all, I think the ICJ opinion is simply a statement of law. It doesn't actually allow actors, whether they're individuals or state, to adjudicate and actually show, and you have to be able to show the causal linkage between the non action on the part of the state and the resulted harm. And as that has pointed out, that's extremely difficult because let's take one of the monitoring issues, like you have to reduce the emissions. So ultimately, you are just 1.5 degrees less than the pre-industrial level. Now, how do you show non-action by the state linking that to the surface temperature of the earth? That's extremely difficult. And as Ted has said, that in fact, these events would have happened anyway, and these are being exacerbated by non-action. Secondly, I think there's a structural problem with the international mechanism now. When the US has actually backed out of the Paris Agreement, and is one of the largest polluters of greenhouse gases, and they are actually now going back on their commitments and allowing fossil fuels, etc. If you can't take them to task, you will never be able to take anybody to task. And in fact, there is a structural problem even in the UN Charter. So, if there's an order by the ICJ, which is extremely unlikely, as Ted points out, how do you enforce it? There's no way of enforcing it. One of the members of the Security Council says no, that's it. This is witnessed in the Gaza dispute, is South Africa versus Israel. You can't do anything about it. So there's a problem not only in terms of the technical issues thrown up, like climate change and showing the causality. Secondly, there's a structural problem with the rules based international order, which is under siege. In fact, there's a major crisis. So, in actual fact, how will you actually bring states internationally to account is a very difficult problem. But there's a plus point here. So, because they have laid down the law domestically, because the law is applicable domestically to countries which have ratified the convention and domesticated it, and in our case is easier. You can go to the domestic court to take your own state to court and make them accountable for their actions. So that's a plus point. So domestically you can, and maybe some states like the island states where there is a major problem of sea level rising, they could take action. But who do you actually attribute the harm to? That's a major problem. So I think there are major issues, not only on the technical side of things, because there are so many factors which have to be taken into account to say that this is the causation for, say, the rise in temperature. Uh, but who's responsible is very difficult. I think one other issue is that under the law, because it's a problematic area, how do you actually make sure that each state contributes its might, as it were, to bringing down emissions of greenhouse gases? Now, there's no obligation, and it's not monitored in the sense that you say this is what you have to do. It's actually left to the state, and the state has to do whatever is in its power to bring down emissions. And if they don't do it, the standard is very difficult to challenge. They can always come around and say this is the problem, etc. So I think there are plus points, but they're minor. But I think it's important to highlight the fact that it's a good statement of law, including one of the issues that it's not the court has actually said that all the treaties and the environmental conventions, the convention itself, the Kyoto Protocol, and the Paris Agreement, and a host of other treaties are all working in tandem, and they have to be applied. So they're all applicable, not agreeing to the notion that were advanced by some states that there's only one agreement, for example, the Paris Agreement on the doctrine of lex specialis. So I think that's a very good thing, and it's a good statement of law for domestic actors to use.
Right, great. Thanks for that excellent overview by both of you. I think so you both seem to agree on one thing, which is the principle of enforceability. Largely, as Anand you also pointed out, it is domestic actors who will have to take their own sovereign states to the court. One issue that does stand out, which appears to be something the court might have overlooked or has not paid attention to, is the fact that the 1.5 threshold that it has spoken about, although the Paris Agreement speaks about a range, is to be crossed very soon, and there hasn't been what shall we say, an adequate understanding of what happens when that threshold crosses. Uh, Anand, do you think that the court ought to have maybe spoken a little bit about that? Considering, as you said, the court's pronouncements, ICJ's pronouncements, often do, evolve into domestic actors taking their own states to court.
Well, the thing is that, as I said, my reading of the opinion is that it's a statement of law. They cannot invent any scientific fact. They have to rely on the scientific facts that are established by other actors, within the UN system or outside it. And they only have to say that we have understood that if you reduce the greenhouse gases by a particular percentage, and that's also tentative, then we can actually make sure that the critical threshold of 1.5 is not achieved. But as you know, in the past, we have not been able to achieve the targets at all internationally. And today, as I said, the US has withdrawn from the Paris Agreement. It's one of the largest polluters, and they've gone back on uh, eradicating fossil fuels. So you have a problem in terms of other states also not working in tandem on this issue. So I feel that the court is handicapped by, they cannot legislate, as it were. They cannot start prescribing something which is not already indicated by scientific experts and UN pronouncements. So I don't think you can expect them to do that. Also, as we were already alluded to the fact that this is a highly technical issue and the judgment is highly technical. If you read it, you will get lost into the technicalities. But I think it's done a good job in keeping it, up to 140 or 50 pages. But I don't think you can expect the court to direct, like a domestic court, bring your levels of emissions down to A, B, C, D. They have said that the responsibility and the duty of the state is to take all measures that are required to ensure that emissions go down. They don't prescribe the exact steps that the states have to take.
Ted, we're speaking just a day after President Donald Trump announced that his administration would scrap the plan, to which undergirds the laws in the United States to limit carbon emissions, the landmark findings that greenhouse gases are harmful to the environment, something which was uh, sort of undergirded in the Obama administration, known as the endangerment findings. So, given that the United States, aside from withdrawing from the Paris Agreement, um, continues to be withdrawing from its overall carbon emissions obligations, how do you view the court's ruling on historical emissions and historical responsibilities? Does the court's ruling help or hinder the progress, particularly for decarbonizing the developing world?
I mean, I think that if you kind of to the original question, and I think also the point that Anand was making in a somewhat different context. I mean, this has always been the problem has always been a problem of sovereignty, which is that sort of sovereign nations are not willing to, shut down their energy systems in order to achieve these climate objectives. And that is the case, no matter kind of what this international court rules, it's just not going to happen. The reality in the United States with the endangerment finding is that it's had no consequence at all. It's never been no one has ever, the Democratic administrations have not succeeded in ever actually making it actionable. The Biden administration attempted to, and it's part of the reason, not the main reason, but one of many reasons why the Democrats lost power. Particularly their efforts to use the endangerment finding and the provisions of the Clean Air Act to enact tailpipe restrictions that would have functionally phased out internal combustion vehicles, passenger vehicles in the United States by 2032 or 2033, was a huge political liability. So I think that there is an idea that you will use, whether it's through the international courts or domestic courts or various other sort of judicial mechanisms, to sort of force sort of painful changes to national energy economies on nations that have been unwilling to take them. And this is just a fantasy. It's not going to happen.
Right. Anand, do you think that the loss and damage fund, which was established a couple of COPs ago, would probably serve as a greater sort of mechanism or a tool in terms of wealthier nations to pay reparations or compensation, if you will, for historical emissions than this court's ruling?
Well, I think that is a false choice, in that neither of these things is likely to motivate wealthy nations to significantly compensate poor nations in the global south for damages due to emissions. And you can just see that from the history of this. I mean, the loss and damages fund, the West and rich countries have never been very serious about these commitments, have never really delivered very much. And often what they've delivered has just been by rebadging existing development aid as climate, for loss and damages or mitigation or adaptation globally. This has not been, it is not appreciably increased or really raised the bar on what rich countries were doing. So I think that if developing nations are kind of counting on Western climate reparations or loss and damages funds or any of this to sort of underwrite their development, they at this point, that again, that's a fantasy. It's not going to happen. And frankly, I think it has some unintended consequences in terms of. I think this idea that there was going to be reparations or loss and damages or international sort of legal action that would sort of result in some substantial transfer of wealth to sort of pay back this climate debt um, has kind of kept uh, a lot of developing countries sort of in the UNFCCC framework, and sort of, I think they've basically kind of legitimized a framework um, that is often actually used to sort of deny them access to energy resources that are really critical both for their development and also, frankly, for improving resilience to climate extremes, whether they're driven by anthropogenic warming or not. So, I think that I don't think that any of these sort of frameworks which were largely sort of invented by Western environmentalists, and then sort of I think human rights and other advocates globally have tried to sort of co-opt them, sort of towards a sort of advancing global equity of various sorts. And I think I think it's a losing game for the developing world. So, I have a lot of skepticism about all of this. And I think the developing world, mostly just needs to kind of get on with their development as best they can. The West is not going to provide, I think, substantially more resources than it has historically, whether those are badged under climate or some other framework. And the further we get out in this, the more the picture, I think there's been an assumption that all of this sort of, sort of the Western nations with this climate debt that would sort of pay this off to poor nations that haven't benefited as much or at all, and that this would kind of result in greater equity. But the further we get out into this century, the more and more of those emissions are not going to, the lion's share of those emissions are not going to have been coming from the U.S. or Europe. They're going to be coming from, even cumulatively from China and India. So now, you have, the Maldives and Tuvalu demanding reparations from India and China. And I don't think that's going to happen.
Right, right. Thank you, Ted. Anand, would you like to respond to that?
Well, I think you have to understand. A lot of commentators are now saying that international conventions, including human rights, were actually devised as a framework to beat the developing countries with. So, for example, what's happening now in the Trump administration violates all international norms with regard to, migration, immigration, etc. But it's never applied there, and they were used to beat the developing countries when, for example, there was genocide, etc. And actually was never seriously meant to correct the wrongs committed by the West. So that was there before the crisis in the West has actually taken root. And now, in fact, you must appreciate that the America and the West are declining economies relatively to say India and China. So now you see the result in the form of Trump. What is he doing? Because the multinationals are not investing in US because of low wage, the wages are very high, and they invest in other countries in China, etc. Trump wants them back. As a result of that, he's actually resorting to measures allowing carbon emissions, but they will never be taken to task. So if you don't have the leader being held to account, you can't expect others to be held to account. So that is a major problem. Today, Trump is in fact gutting the American economy rather than actually improving it. So if you have that kind of scenario, with the West actually declining in terms of economic power, and then they are not complying with international law. And I always use the example of Gaza and Israel. When there's a clear case made out by a direction of the international court on genocide. There is no action taken, and in fact, the US is actually blocking it through the Security Council. The rules based order has actually collapsed, and the writing is in the wall for other things, including climate change, and where the actual responsibility is on the states to take all measures necessary. And if they don't take the measures, they can always come and say that, in fact, even if there's a court case, which I doubt internationally, they'll have enough reason to say no because causal linkages are very difficult to prove. But as I said earlier, it is the domestic courts which will be important because environmental activists can go to court and say the government in India has not done this, this, that, and we can show it locally. It's easier to show that locally than internationally. But this is also must take into account the fact that in India, like the US, the courts have become actually very feeble. They are not exercising their powers as they should. Nobody would have imagined how the Supreme Court is behaving now 10 years ago. They're not actually acting on the basis of the law and the Constitution, like the U.S. court. For example, the Dobbs decision, the rolling back of affirmative action. Nobody would have imagined that 10 years ago, but that's what's happening. So there are major problems in terms of implementing the law, particularly in the case of environmental issues, and also going to court and getting the courts to say yes, you're right, and reparation and damages. The things are not looking too good. Let me put it that way.
Right. So, Anand, would you agree with Ted's assessment that developing countries must not rely, or at least, I don't know if fight for is the
Rely on
right
the
phrase, but
reparations, etc. I don't think we should. Yeah, but that doesn't mean we should abdicate our responsibility in terms of not complying with the greenhouse gas emissions to be lowered down, because actually that primarily impacts on Indians. You know, you cannot just rely on payment and then say, okay, we can do whatever we want, because actually Indians are badly affected. And the domestic policies in India, for example, if they don't follow the emissions norms, etc., it's affecting Indians. You look at the Delhi scenario. Every winter we have such a major problem. Nothing is done about it. There are so many issues. So you can't say we will rely on them and not do anything ourselves. We have to be, I mean, our governments must take a clear stand and act on it and say we are not going to allow, greenhouse gas emissions, and we will use technology to change it. But there has to be will, and you have to understand also that all governments are actually lobbied by corporate interests. For example, in the COVID scenario, the whole thing was set by the industry, the pharmaceutical industry. The governments were just they didn't have their independent opinion on it. They just behave as toadies to the pharmaceutical industry. And the same thing is happening in India. The government is actually acting on the interests of the corporates, and they don't want to spend money to install new technologies which costs money, and that then thereby lower their profits. So you have a very difficult situation now in a host of areas. So I don't think um, we should actually rely upon reparations or compensation from the fund, and actually act on it, because we should think that we have to tackle this problem. It is affecting our people apart from our neighbors and the rest of the world. We must make sure that greenhouse gas emissions are lowered. That's in our interest. And if you use technology, you actually become a leader in that technological area, and then you start exporting. You have to see it from that perspective also. The moment you start using newer and newer technologies, it is beneficial to your
right.
industry.
Isn't
The only thing is
yes,
that Sorry, loss of
Yeah, I
job.
do. I do follow what you're saying. I think, Ted, you've argued that in your book and in general in your writing that um, economic growth must be decoupled from the sort of environmental movement and a sort of what you call eco-modernism, particularly using technology to decarbonize, etc. Um, but going by just what you're saying, that sort of technology, which is crucial to decarbonize, if it's not coming to the developing world, then it's going to hinder this process, isn't it? And is there a mechanism? How do you view this ruling, particularly when it comes to technology transfer for reducing carbon emissions?
I mean, I think there was an idea, back 30 years ago that, the directionality on all this technological transfer and technological change was going to be from the advanced, developed, rich West to poor, technologically backwards developing countries. And, that's not really what's happening. I mean, I don't know, you classify China how you will. But, you know, at this point, a lot of that technology is going from China both to the West and to other parts of the and to the developing world. India may end up also sort of developing technological capacities that it is transferring um, to other places. So again, I think there's this old idea that goes all the way back to 1990 and the original convention that the West would sort of develop all these technologies and deploy them, and we would have these separate and differentiated responsibilities, and then the West would sort of beneficently hand them off to poor countries to pay off their carbon debt. And it just 35 years later, the world does not look like this at all. The West is arguably sort of subsidizing the Chinese clean manufacturing sector, which is then transferring these technologies back to the West, which subsidizes them. And in a variety of ways, that's also kind of driven down the costs of many of these technologies over time. So I think there's multiple ways in which the entire sort of UNFCCC framework, which this international court opinion is based upon, in part, it's just completely outdated. It doesn't actually reflect the world that we're actually living in. But of course, there's sort of so much sunk sort of capital of various sorts in that framework that kind of no one can just sort of, you don't get to sort of tear it up and start over. But I think if you were actually kind of starting over today and looking at the climate issue and looking at, the realities of China and India, I don't think you would craft that framework in the same way that it was crafted back in 1990.
Right. Right. So I think you both agree that we're at a sort of an inflection point where, one, the rules based order has sort of collapsed, as Anand said. And secondly, that emissions has in fact been rising from the global south, given their developmental gains and the sort of particularly nations like India and China, which are now maybe the second or the third largest contributors in terms of nation states to carbon emissions globally, and that technology transfer has in fact been both ways as opposed to one. That's interesting indeed. Is there anything positive that you see, Ted, in this ruling that's a sort of a takeaway for you? And we can probably close with that and Anand's responses.
I'll just say that to the point I just made, it just feels like a little bit of a kind of zombie sort of ruling reflecting this old framework that is it just doesn't make any sense anymore on multiple levels. And so I think there's a bunch of this happening right now, and part of it is because of this sort of collapse of this sort of the old internationalism and the old sort of post Cold War international order that sort of the climate issue is really kind of quite central to. Um, And so you get these, various sorts of kind of last gasps to try to keep it relevant. And I think this international court opinion judgment is one of them.
Right. Well, thank you. And Anand, your closing thoughts?
Well, as I said earlier, it'll have an important impact and it'll be useful for domestic courts, but internationally, I think there's a very bleak future.
This question of applicability, that the fact, this alarmist view, for example, Claire Coutinho, the Secretary of Energy in the United Kingdom, mentioned that we would have litigations against developed nations tomorrow, is unfounded, would you say, Anand?
I would say that because I think this is alarmist for no reason. If you read the judgment, you actually, as a lawyer, you'll find, okay, how do I do it? What do I have to prove? And there's no indication of that clearly. And whatever is there is very vague. So I don't think internationally that would actually have much impact. But as I said, domestically you can use it. Say that your particular government is not acting to reduce greenhouse gas emissions, and this should be the thing, and this is not being done. So I think that's more useful. Internationally is very tough.
Right. Well, thank you so much. On that note, thank you, Ted, for making time on Wednesday evening there in California, and also Anand from New Delhi. Thank you indeed for this insightful conversation. And that's it from me, Kunal Shankar from The Hindu for Parley. Thank you.
Thanks for having us.
Thank you.